14A District Court. I'm the Honorable Judge Simpson.
Can you guys hear that?
And I'm about to provide to you valuable information regarding this project and other matters. This is the landlord-tenant or summary proceedings document. You are here for a retrial. Your landlord has made allegations and findings that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for a lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. You have the right to have your case heard in proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Grand Arbor and Ypsilanti Township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. Right to rental and other housing assistance. Within 5 days of first receiving these advice of rights and information, you must provide written proof to the court that an application for assistance has been submitted for process. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.dish.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 724-961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is 724-973-4540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 745-6748. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside of Michigan and local community dispute resolution programs are approximately resources. Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. Future rental hostilities, your case may be resolved by conditional dismissal and legal judgment, if that is approved by all the parties and the court. It is important that you understand these things. If you have any questions, please feel free to address the court.
We have 675. All right. The 14A District Court of County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson presides.
You may be seated.
Yeah. Sure.
Court does call the case of Arbor Manor versus Jamaica Jones.
Good afternoon, Your Honor. James Spink to the plaintiff.
Hello.
Hi,
What's your name?
Jamaica.
All right. What are we doing on this case?
Balance is 2803. Which is a little reduction from where she was,
Yeah.
20 something.
So my understanding is that there were some repair issues. Did those get taken care of, or where are we with those?
No, it never got to.
Looks like she was supposed to file a written answer by today.
She was supposed to file a written answer by today. She did submit her rental assistance form, so she would be entitled to another adjournment on this. But
Whatever you want to do, I don't have any information on the repairs, but I'll find out about them.
all right, because my understanding is from the last, right, if I'm wrong, but she had basically stated what some of the repairs were, what the repairs were, and council had indicated they were going to get to the landlord to try to talk about that.
Yeah, the note I have just says she has repair issues.
Okay. All right. Well, let's see if we can try to figure that out. November 21st, 2025 at 1 p.m. for you to come back. Ma'am, is there anything that you can pay either into escrow or to the landlord between that time and then and now?
I really honestly don't want to pay until they fix all my repairs because
I understand that. Okay. And that's why the option is also to pay into the court.
okay.
All right.
Yeah, I can pay into the court.
Okay. So how much can you pay?
1,100.
1,100?
1,100, yeah.
Okay, no, it's okay. It's okay. I got you. All right. So what I'll do is that you'll pay 1,100, but you'll pay that into court escrow. All right.
When will you do that?
Pardon?
When?
Yeah, when they're,
Today.
okay. It'll have to be cash so that you know.
Okay.
So, all right. I'll put that you'll do that by Monday. All right. In case you have to do whatever. Okay. The other thing, have you heard back from your SER at all or no?
They denied it.
Okay. Okay. So they gave you an answer on that. Have you contacted Hawk regarding payment of the other amount or anything?
No.
No? Okay. So you might want to reach out to them. There's some funding that is available in case you need it.
Okay.
Okay? All right.
All right. Thank you.
Thank you.
Your Honor, could we just reserve escrow just in case something
Yes.
goes wrong? I won't submit an order unless she didn't pay into the court.
Court. Okay. That's good. Okay.
Thank you.
All right. Thank you. Cherry Hill Administration versus Dion Ragley.
Chief Sink for the plaintiff.
Hello.
Hey, how you doing?
What's your name? Name?
Dion Ragley.
You?
Kalila Horton from Washington County.
I thought so. How are you today?
Good.
All right.
How are you?
All right. Where are we on this case, Mr. Ragley's case?
I've got the balance at 9,900. They did give us a list of money orders and he's been credited for all but two of them. That total, like,
1,000. Was it more than that? It was 500 and
it was 675 and 550, so 1,225.
1225.
So he thinks that he submitted 1,225 in money orders, one for 675 and one for 550 that we don't have.
Okay, so there's about 1,200. Okay.
I think he intends to move.
Yeah.
Okay. Okay, so you're gonna move?
Yes.
Okay. When do you plan on doing
Well, after I got all this information today, so in the next couple of weeks.
24.
24. So when you,
Yeah.
I, just listen,
Yeah. Oh,
but you got someplace you're going or?
yeah, I have somewhere to go until the meantime.
Okay, so you got someplace to temporarily kind
Yeah,
of stay. You're not gonna just leave because you think you have to leave right now.
No,
Have to
no,
be
no,
out there.
Right,
Okay,
yeah.
that's what I want to make sure. Not gonna happen.
no.
Okay, so you think you can be out by what date?
I just got all this information today. It's as far as
No,
I
I got
didn't need
you,
some time because I got to get storage, a truck, and move stuff out. So,
When you think you can be out?
uh,
Today the
Let
14th.
me ask you this. Today, can you be out before the end of the month? You think? Or you're gonna need more time than that?
yeah, I'll probably need a little bit more time because of how I get paid and stuff. So,
All
and I
right.
got to have money.
Okay, so here's what I'm gonna do, because I normally would just give a judgment today, but the number is not gonna, it's gonna be what it is. So I'm gonna adjourn you out, Mr. Ragland, and let you come back on the 21st, 2025 at 1 p.m. Okay? Here's what I want you to do. It's likely I'm gonna issue a judgment at that time, give you a time frame
Okay.
by which you need to move out.
Yes.
But I'm trying to give you time to get a plan in place for how you're going to do this.
Right.
You're not just trying to pile everything into a truck and just go.
Right. Yeah.
Okay. And I think that's what you don't want to do.
Right. Right. Yeah.
And so I'm going to give you that with this week to try to get that straight.
Okay.
We could just make it the
No,
28th. Oh, no, that's it. Well, that's a.
I put it into the next month. He may be there, but I want to. I hear you, Mr. Fink, but
I would have to come back if we can figure out the.
right. And if it can be no, I hear you, but I also don't want Mr. Ragland. I want him to have time to kind of
Yeah.
be able to make some decisions and
Right.
just try to work it out for himself in a lot of ways. He's got it. The first part figured out that he's got to move.
Right.
The next part is he's got to figure out how he's going to do that
Exactly.
and as comfortable as move can be, comfortably do it. So I'm going to do it that way. Okay.
Yeah. That's
Right,
right.
but when you come back, I need you to have sort of things
Yeah. Oh,
in
yeah.
place as to how you're going to do this.
Yes. No. No.
Okay.
Yep.
All right.
All right.
Take care.
All right. Thank you. Appreciate
Thank
you.
you. Have a good one.
Forrest Knoll versus Shemaya Charles.
Jason for the plaintiff.
Charles, not here. You've previously been sworn. You may proceed.
I'm still sworn.
Yes.
Your Honor, this is an action for non-payment of rent. This defendant owes $666 in rent. The costs are $175 for a total possession only judgment of $841.
Judgment to the plaintiff. That's by default for possession. Redemption amount requested. With issue intent case. Forrest Knoll versus Rosalind Latt.
James Fink for the plaintiff.
Yeah, I gave him.
Let me see if it's on.
I got a receipt if you want.
It should be on here. Let me look.
The 500.
I gave him 665 yesterday.
You paid more than what you said you were going to.
Yeah. Oh, I got the receipt in here. That's why.
No, it's okay.
My ledger is dated yesterday and it does not include that. So assuming that's correct, she would be, the balance today is $1,278. If she paid 600, she'll only need to pay another 678.
When do you think that can happen, ma'am?
I can Instacart and have it by Thursday, or I get paid.
You can have it by next Thursday?
Yeah.
Is Thursday coming up?
The week of Wednesday after next too, if, to be safe.
Well, if you get it paid by next, he's gonna adjourn it a week, and if you get it paid by next Thursday, I can.
They'll dismiss it.
Okay.
You do that?
Yeah.
You want to do that?
Yeah.
Okay. I'll adjourn it to November 21st, 2025 at 1 PM. Okay? Get it paid and hopefully we can just dismiss this.
Okay, thank you.
You take care.
One of my brother's best friends.
Really?
Yeah.
Peninsula Place Apartments versus Michael Pugh. Yes. Mr. Pugh?
Yes.
Okay, there he is.
James, thank you for the plan.
All right, what do you have as a plan? Well, you looked that up. Did you pay the 800 already?
Yes, I did.
Okay, when did you do that?
I did it, I would say probably 3 days ago.
Okay, so you paid it earlier than, okay. So they may hit in the balance.
I have 2170.
Given what, well, no, because November came around. The last time you were here was October 31st. Okay. So how are you intending on getting the rest of this paid off?
So I start my new job next week, and that was our main issue was like seeing how I would pay it until I started work. But I had paid the 800, and I start working next week.
Okay. Then you don't get paid for.
They have an option. It's like it's weekly pay, but they have an option after setup where I can get paid like after every shift.
Okay, I see what you're saying. All right, so here's what I'm going to do, sir. I'm going to find no tribal issue. I'm going to issue a judgment for possession in that full amount. And what I'm going to suggest that you do, I'll give you a little bit more time, and I'll give you till, it normally would be the 24th, but a writ will be November 26th, so I'll give a couple more days. You need to reach out to the landlord and the attorney's office, have a concrete plan, see if they can work with you to give you time to get this paid off. Okay?
Okay, and what time on the 26th? Or
Well, that's not a court date. That's a date that they can at least request the court to have you evicted. So that's why you gotta call, you gotta get to them, see if you can work it out based upon how your pay is. Because you're right, we're waiting on you to get yourself working. You paid the 80. That kind of kept you sort of steady coming into November. But now you got to get with them and get a plan as to how you're going to move forward.
okay,
All right?
all right.
Okay, I've signed that judgment. Thank you. River Drive Apartments versus Ann Marquette. Marquette, I should say.
James, thank you for the plaintiff.
Don't know why I'm putting an extra syllable in it.
Your Honor, can we either approach or go off the record?
Yeah, correct.
Welcome to the 14th District Court. I'm Aaron J. Cedric Simpson, and I'm about to provide you valuable information regarding this current and other landlord-tenant. Landlord-tenant or summary proceedings. You are here for a retrial. Your landlord has made allegations and claims that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for these violations. After today, you will come back for an additional hearing or trial. Landlord agrees so.
Okay.
In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and its surrounding township is covered in this court. You also have the right to demand a trial measure. If you want a trial measure, you must demand it orally at the first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. You have the right to rental and other housing assistance. Within 5 days of the first receiving these advice, rights, and information, you must provide written proof to the court that an application for assistance has been submitted for process. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mitch.gov. Assistance may also be obtained by contacting Housing Access for Washington County on email response. All can be reached at their phone number area 961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is area code 724-973-4540. Also, you may obtain housing assistance and other resources, or coordinated entry resources. Their phone number is 734-544-6748. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside court. The Michigan and local community dispute resolution programs are a possible resource. Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-21. To protect your credit and future rental losses, your case may be resolved by conditional dismissal of the judge, if that is approved by all the parties in the court. It is important that you understand these things. If you have any questions, please feel free to address the board during the
District Court of the County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson presiding.
Maybe seated. Hampton to Clover Lane versus Clear Up Beck.
Brett Decker for the plaintiff.
Clear Up Beck?
At this time, we move to dismiss with
Oh.
prejudice, Your Honor. She paid in full this morning.
Fantastic. Case dismissed. That took out. Pine to Clover Lane versus Ronaldo Eccleston.
Brett Decker.
Your name?
Rolando Eccles.
All right. And where are we on this case?
Well, right now with November rent, I'm at 2370.38. There's cost of 175, so he needs to pay 2545.38 to get it caught up.
All right, sir. How are you intending on getting this done?
I started door dashing and just working. I'm sorry, I just came up short. I applied for help with MI Bridges and it was turned down. They didn't want to take into account my seasonal employment that starts in December. They were only looking at my November financials, and so that was turned down. And so I'm just going to continue to work and try to get there. I've been a resident for about 3 years, and I just took a pay cut and insurance premium hike that caused me to fall behind.
Okay. Have you reached out to Hawk at all?
I don't know who Hawk is. No, I just did the MI Bridges.
Okay. Hawk is an agency through Washtenaw County. They do have funding now. With this amount, if you were to otherwise qualify, you're under the 3,000 cap. Okay. So I'd suggest, we'll write down the number for you and give it to you. It's at 961-1999. So you can give them a call. But at this point, I'm going to have to issue a judgment, but I'll give you time to call them.
Understood.
And you can let them know that here's your kind of drop date and see what they can do to maybe help you out.
Understood. Okay. Thank you.
So I'll find you a tribal issue after a hearing on this case. I'll grant judgment for possession. Total amount of that judgment is $25,45.38 inclusive of cost. And what is today? 14. And what I will do is I'm going to change the writ date on this too. I'm going to give him a couple more days on this, so the 26th. Okay.
Thank you.
And we'll get that number to you. They gave it to you.
Got it to me, yes.
So then I suggest that what you do is right after leaving here, give them a call.
Will do.
Okay. Then hopefully they'll be able to help you out.
Will do. Thank you very much.
All right. Good luck to you.
Thank you.
Thank you, Judge. Have a good weekend.
You do the same. Augusta Woods versus Eric Roden.
Richard Robbins.
Pardon?
It's either Eric Roden or Richard Robbins. Richard Robbins.
Please, second.
Yes, I see that. Okay. Hold on just 1 second, sir. Who's here? Miss Hall?
Miss Hall, and she's in one of the side rooms.
Oh, okay. So that's you guys see. A.M. Kasham versus DBA Princess Villas versus Ratiba Farah. Okay, who do I have here? Your name?
Kashamia.
Your name?
Mahar Kasham.
Okay. Like with everything in my day, I've got Kashams all over, but I don't have, I shouldn't say that.
We just keep
You guys know what I mean. But I don't have, she's not here.
I do not have her.
She informed me that she wasn't going to be able to make it today.
Hold on. Go ahead, what?
She informed me she wasn't going to be able to make it today. We were just hoping, I think she's working with Hawks right now.
With who?
Is it Hawks?
Hawk? Okay.
Thank you, Hawks. Sorry.
She's trying to work with Hawk to get it paid.
Yes.
How much is the total amount owing at this point?
At this point, I believe it's $3,200.
They're about 3,200 here.
They got some assistance and got it paid down a little bit. So,
pardon?
They should be able to get the assistance and get it paid down, hopefully.
If they can get it,
Yes,
if it's 32 even, then she's right around that limit of the maximum amount they'll pay if they're going to pay it. She would just have to probably, with this number, come up with about 200 to bring it under that 3,000 to pay. So what do you want me to do today?
Is there any way we could adjourn it for a little bit longer to see if she could get the help?
See, I expected you to ask me. He never is that nice.
That's my son. He take care of everything.
This courtroom session isn't about a single tenant. It's about the real-life struggles many renters face when falling behind on payments while trying to keep a roof over their heads. As Judge Simpson begins hearing case after case, a pattern quickly emerges. Some tenants are fighting to stay in their homes. Others are trying to buy more time, and many are desperately seeking rental assistance before eviction becomes a reality. What makes these hearings especially interesting is that the judge isn't simply issuing rulings. He's actively trying to understand each person's situation, from repair disputes and denied assistance applications to relocation plans and payment arrangements. Every case presents a different challenge. But despite the judge's patience and willingness to work with tenants, one question remains. Who has a realistic path forward, and who may be running out of options? As these cases unfold, the answers become increasingly important.
Talking to the tenants, is that what's going on?
I do believe so.
She came in and walked back out with the tenant, or? Yeah, if she's still talking to someone. What's that? Augusta Woods versus Eric Roden and Richard Robbins.
Dana Hall on behalf of Augusta.
Your name, sir?
Richard Robbins.
All right, thank you. What is plaintiff's claim in this case?
Yeah, this is a non-payment of rent case. I have that the rent was $2,812.27. Costs were $218. The total is $3,030.27. I hadn't gotten a chance to speak with Mr. Roden.
You said it's how much?
$3,030.27.
Okay. There's supposed to be an $1,100 payment on the 12th. That happened or no?
No, we'll have the 3,030.27 paid by Friday, the 21st, 1 week from today, the total amount.
You'll have the total amount paid.
Yep.
All right, because I'm going to grant them a judgment finding no tribal issue after a hearing. I'll grant a judgment for possession. Total amount of the $3,030.27.
We have until the 24th.
But the writ to issue the 24th. So you're going to have it paid by the 21st, right?
21st.
All right. So no writ until the 24th that Monday.
Okay. It still stands at the 24th.
Pardon?
The date still stands at the 24th, sir?
What do you mean?
Oh, Your Honor, I was showing him the writ date on there that they.
Oh, yeah, it's the 24th.
Okay.
But you're going to pay it the 21st. Okay. Then you'll be good. Okay.
Okay.
Thank you.
Thank you. Awesome. All right. Have a nice day.
You do the same. Beal Properties versus Emery Oaks.
Dana Hall on behalf of Beal Property. Oaks here.
Your name?
Emery Oaks.
All right. And where are we on this one?
Your Honor, I spoke with Mr. Oaks and we have a consent. We have a conditional dismissal. The terms are that the total, including court costs, to be paid is $3,270. Defendant will pay monthly rent on time starting December 1st, 2025. Defendant shall pay an additional $750 every month before the 15th, starting November 15th, 2025. Last arrears payment will be $720 on February 15th, 2026. Should be. Future late fees abated with timely payments, and defendant waives 56-day rule and checkbox 4B.
All right. Sir, you understand all of that?
Yes, Your Honor.
Do you have any questions regarding this conditional order of dismissal?
No, Your Honor.
All right. Sir, you are appearing before the court. You are unrepresented by counsel. You would have 3 business days to think about this conditional order of dismissal. If you believe that there's some misunderstanding, some confusion, or some right you did not assert, you would have to file a motion with the court within that time frame. You understand that?
Yes, Your Honor.
All right. Okay. I will have signed and I will enter the conditional order of dismissal. Thank you guys for working it out. Good luck.
Have a nice afternoon, Your Honor.
You too. Investors Realty Group versus Alexandra Streety.
And Dana, on behalf of Investors Realty Group.
Hello.
Hi,
Your name?
Alexandra Bell Street.
Okay. And where are we on this case?
Well, Your Honor, I spoke with Ms. Streety. She indicated to me that she filed the DC 539 form this past Wednesday, and on the same day she was approved by SOS for
She was approved?
yes, for the balance minus $50. So she owes $2,999. SOS approved her for $2,949.
Okay, yeah, but that's fine. I mean, I'm not.
So if we could adjourn a couple weeks.
You want a couple weeks or you want the 21st? I have the 21st, but because of the holiday, I didn't have the 5th. But that's going to kick it, right? It's going to kick you over into another month.
They said that, because they also emailed with Colin Kennedy, which is who I speak to. That's my contact with the Investors Realty. And they said to allow 2 weeks and the payment would clear 2 weeks.
Okay, so here's what I'm going to do. What's your monthly rent?
$1,100.
Okay. Do you have plans on how you're going to pay December?
I'm going to play it December 3rd because I get paid.
Okay, so you're going to get that paid December 3rd. Okay. Your late fee kicks in on the
5th.
5th? Okay. I'm going to just tell you something. Then, in that circumstance that you have figured out how you're going to get December paid, I don't mind putting it out to the 5th.
Okay.
And then hopefully that check will come in. If it comes in before the end of November, they're going to dismiss in any event.
Okay.
Okay. So I'll put it to December 5th, 2025 at 3 p.m. Okay, now I'm going to just tell you this so that when you, and it's not tricking the system, but I just don't want you to get caught up in something. Come December, like I try to make sure that the money's coming in from the agency are there.
Mm-hmm.
Okay, and that they're not looking for a new ledger after you paid.
Yeah.
You follow me? Because I just don't want you shorted by what they might issue. It shouldn't be a problem here, but I just try to make sure that they've paid, then you pay the funds.
Okay. Yeah, I understand.
Got it? But I don't want you to get a late fee, so get it in.
Yeah, I'll follow up with them.
Okay, we'll see you then.
All right.
Showcase Investments versus Danielle Boyd.
On behalf of Showcase Investments.
Hello.
Hi.
What's your name?
Danielle Boyd.
Okay. And what's the claim in this case?
Your Honor, the total due, and just so you know, we do have a consent judgment.
Oh, okay. Go ahead then. What's the consent judgment?
The total due is $9,228.76. So what we've agreed to is to enter a consent judgment where defendant will pay her regular monthly rent on time starting December 1st, 2025. And then the past due balance will be paid by March 15th, 2026, and that the parties waive the 56-day rule.
Okay, so she's going to be paying her monthly rent on time. And basically you're giving her till March to wipe out this back balance, but not requiring monthly payments.
Correct.
All right. Okay. Is that your understanding, ma'am?
Yes.
All right. Did you have any questions on the, you did this in form of a judgment?
Yes.
Okay. Do you have any questions regarding anything on this judgment?
No.
All right. And you understand its terms?
Yes.
Okay. And you understand that they could issue or request an order of eviction if you didn't pay your rent timely, as well as not pay the back balance?
Yes.
You understand that part of it? Okay. Any other questions you have regarding this?
No.
No? All right. I will sign off on that judgment. And ma'am, you are unrepresented by counsel. This is a consent judgment. You have 3 business days from the time of my signing of the judgment to file a motion with the court to set this judgment aside. If you believe that for whatever reason you're mistaken about something, there's some confusion on your part or some right you did not assert. You understand that?
Yes, Your Honor.
All right. Doesn't mean that I would do it. It's just you have that time frame to look at it and think about it. All right?
Yes, thank you.
Thank you. Woodview Commons versus Clarence Hester and Lee Hester.
Dana Hall on behalf of Woodview Commons.
All right. Hello, what's your name?
Hi, my name is Leah Hester.
All right. And what is the claim in this case?
Well, this is a non-payment of rent case, Your Honor, but I was just looking at my notes and they are saying that they moved out.
Oh.
At the last hearing, I don't.
Have you vacated the premises, ma'am?
Yes, I submitted exhibits. We have been out of the unit since August, which
That's right.
the apartment complex was aware of. I had sent them an email in September notifying them of the unit was vacant, and they responded back and said, okay, they were going to reach out to the attorney for a date. All correspondence has been me initiating. I've reached out several times to try to get this eviction date, and they're still charging rent knowing that we've been vacated since August.
She did indicate that at the last hearing. Because you're, what, in Texas now?
No, in Ohio.
With that accent? I'm not going to worry. All right, that's all right. No.
My family is from the South, but no, we're in Ohio.
Oh, okay. All right. She was talking like she was from Texas or Alabama or something. I didn't know. All right. But anyway, they did apprise me they were out of state. The problem is whoever appeared, I don't know if it was Judge Hall or not, but was not aware of that. And I put it over to this date primarily because this was a possession case and they're saying they're out and nobody knew.
Right, I think they didn't get the keys back. Did she turn in the keys?
Did you turn in the keys?
So it was a key. There's like a keyless entry with a key fob. And when my son moved out, I was the co-signer on the apartment. The office hours were closed, but in no indication did they tell me to return keys. They known that we've been out of the unit. I would have gladly mailed the key. Well, it's a fob, so it's really just like they electronically just deny access. So it's not really a key. But I would have gladly, but if you look at the emails, there's no mention of returning keys.
Yeah, there's a whole email chain here.
Well, I guess if they're considered to have possession, then
Pardon?
If they can take possession of the unit, then.
Oh yeah, they can take your client can. She was really surrendering it at the last
right.
Yeah.
one.
I was just disputing the amount. A previous attorney who met that last week, he had mentioned like $11,000. And Your Honor, from, my standpoint is that we have not had possession of the unit since the end of August, which they were aware of and have not tried to mitigate the loss or damages since that time. And he's still incurring charges for September, October, and also November.
Right. Here's what I'm going to do. It's going to be September, October, November. She has voluntarily surrendered. The landlord can take possession of the premises. I'm going to dismiss this case without prejudice because it's a possession case and she's in possession. What I will indicate so that for future reference, because it may not come back before me, if they sue for the balance, and I realize you're disputing the balance, but we're not talking about the money here today. If they sue for the balance, I've noted in this file that the defendant gave up possession the end of August, or at least it's alleged, and that disputes rent for September, October, and November. So keep the case number, this case number, so that if that does come up, you can ask them to look at the file here. I put that in there purposely. Okay?
Okay, and with us being out of state, will we receive, like, can I give my forwarding address so we can receive the notification of if this goes again before a judge? Would it be for non-payment at that point? I'm sorry, I just want to make sure I'm clear.
I guess I'm not clear what you're asking.
So it's a possibility that this can be brought to court again. Would it be for non-payment that time? Or?
It would be for a money judgment on what they're claiming you owe.
Okay.
Okay, I'm not making a finding on what you owe. You tell me you're out. They only want possession in this case. You surrendered possession in my mind. You're disputing these 3 months basically because this is when this would have been issued. And if your question really is, if they get to you, then are they going to have your right address and the like? One of the things that you can do is, if you believe that there's monies that you owe, you can certainly contact the landlord and try to arrange some type of payment in lieu of a court proceeding happening to pay off an agreed upon amount on this amount.
Okay. Well, I tried to do that initially, and they said that it was due in full. So that's kind of how we ended up here. So
got it. I see.
Yeah. So
and I'll just tell you, ma'am, I get why they may say that. That's not the way it really works. Because even if you got a judgment for the $11,000, if you were to show that you can't pay the $11,000 and wanted a payment plan, the court's going to give you a payment plan. So, hey.
Okay.
I don't know. Okay.
I'll give the forwarding address if something does come up to the clerk. I'll call in and give that to them so you guys will have it.
So they have it. Okay. Yes. Very good. All right.
Thank you. Have a good day.
And you may want to, if you're going to call the clerks here, you may want to ask them if, no, because they're going to charge. Tell you what, ma'am, she could put it in a chat without you, or you're going to put yours in and have her.
What do you want her to put in the chat? Her address?
Her email, because I want to get her a copy of the contract.
Oh, I can put my.
Okay. My coordinator is going to put her email in for you to give us your email, because we don't want to publicize it out there, so that I can send you the front of the card stock that I have here so that you have that for your records, what I wrote.
Okay. But in the meantime, the charges will cease, correct? Going forward.
They should. Well, I'm not in charge of what they do, but they shouldn't be charging anything.
Okay. All right.
All right.
Email
and when she sends you the card stock, don't laugh at my hieroglyphic writing. It says what I say it says. All right.
No, thank you so much. Y'all have a good day.
All right. You do this. She said y'all. She's not from Ohio. She's just, all right. You take care.
You too. Bye-bye.
That's fine. Thank you.
Thank you, Miss Hall.
Bye.
All right. Bye-bye. All right. Court stands in recess.
All rise. You may be seated.
This is the landlord-tenant or secondary proceedings right here, or pre-trial. Your landlord has made allegations of claims that you should be evicted, that you have not paid your rent, or because they seek termination of tenancy or lease violation. After today, you will come back for an additional hearing or trial. That's what the landlord each Sunday. These proceedings, you have the right to have your case heard in proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14 District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washtenaw County outside of the city of Ann Arbor and in Fleming Township is covered in this code. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. You have the right to rental and other housing assistance. Within 5 days of first receiving these advice, rights, and information, you must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mish.gov. Assistance may also be obtained by contacting Housing Access for Washtenaw County, commonly known as HAWK. HAWK can be reached at their phone number of area code 734-961-1999. Additional assistance is also available through Washtenaw County Veteran Services. Their phone number is area code 734-973-4540. Also, you may obtain housing assistance and other resources. Coordinated entry resources. Their phone number is 734-546748. You do not need a judgment to obtain assistance from any of these agents. The summons and complaint are sufficient. You have a right to reach an agreement outside of Michigan.
This may be one of the most significant moments in the entire hearing. Unlike many of the earlier cases that focus primarily on unpaid rent, this dispute centers on possession of the property itself. The tenant argues that the unit was vacated months earlier and that the landlord continued charging rent despite knowing property was no longer occupied. That distinction matters because possession and monetary damages are separate legal issues. Judge Simpson carefully focuses on the immediate question before the court, whether the landlord still needs possession of the property. After reviewing the circumstances, he concludes that possession has effectively been surrendered and dismisses the eviction action without prejudice. However, he also makes it clear that the dispute over the alleged balance could still be addressed in a future proceeding. It's a reminder that even when an eviction case ends, financial disagreements between landlords and tenants can continue long after someone moves out.